Before we get started, a quick disclaimer. This podcast is for educational and informational purposes only. Nothing shared here should be taken as legal or medical advice, and listening to this podcast does not create an attorney-client or consulting relationship. Every case is unique and laws vary by jurisdiction, so always consult with a qualified attorney or appropriate professional regarding your specific situation. Now that we've got that covered, let's get into it. Welcome to the Attorneys Resource Legal Nurse Podcast, where we spotlight attorneys in personal injury, medical malpractice, workers' compensation, criminal, and healthcare law through focused conversations on the intersection of medicine and litigation. Each episode explores how medical insight strengthens legal strategy and case outcomes while improving collaboration, communication, and effectiveness in medically complex cases. Today, we are excited to welcome Ken Hoffman, a personal injury attorney with Mitchell Hoffman Wolf in Chicago, Illinois. Ken represents people in personal injury and wrongful death cases arising from car and truck accidents, medical malpractice, slip and falls, worksite injuries, and nursing home neglect. The singular focus of his personal injury practice is on protecting his clients' interests, getting them the resources they need to find their way through tragedy. Over 30 years, he has secured numerous multi-million-dollar settlements and jury verdicts for clients. Welcome, Ken. We are excited to have you here today.
Well, happy to be here. Thanks for having me on.
Yes, I'm very interested. I did a little digging in your website to learn about all the different jury verdicts that you have won for your clients, and tell our audience a little bit about what you mean by finding resources to help your clients through their tragedy.
Well, no one ever plans on being a plaintiff in a personal injury case. There's no National Association of Prospective Injured People out there. No one's seeking to be a plaintiff in a personal injury case. But when these things do happen, quite often they lead to tragic consequences. People who have a need for ongoing medical care, or they've lost a loved one who's the primary wage earner in the household. And when we're handling a case, one of our primary focuses, in addition to establishing liability against the at-fault party, is making sure that damages fully compensate our client for the losses they suffered. That could mean making sure they have the future medical care that they need, adaptations to the home or their vehicle. In cases where you have a loss of a main wage earner in a house, making sure that the damages in the settlement provides for the family's ongoing needs, not just at present, but when there's small children involved, making sure that their college needs are taken care of and they don't have any financial concerns going forward.
Okay, so what inspired you into this line of work? How did you find yourself where you are today?
I knew when I was in law school that I really enjoyed being in the courtroom. And I was a national competitor for the law school's moot court team. We went to Omaha, Nebraska to compete in a regional competition a long time ago. And then from there, my first job out of school was actually doing defense work in personal injury and medical malpractice cases for a firm here in Chicago. And I really enjoyed that aspect of the work. But I saw the plaintiff side as being more well suited to my personality and where I wanted to be in my career. So after 3 years doing defense work, I jumped over the fence, so to speak, and joined a plaintiff's firm here in Chicago. That was 1994, where I met my current partners, Paul Wolf and Jay Mitchell, and we started this firm together in March of 1998.
Where do you feel like you've done or made the greatest difference for clients? You've worked both plaintiff and defense. Which one? You've been in plaintiff work now since 1994, so I can guess staying there for this length of time, you've had the most rewarding experiences. But I guess what are the primary differences and why did you move from defense work into plaintiff work?
I think the primary reason I made the change was just from a personality standpoint. Defense work is work for insurance companies, and it's more of a corporate setting. and a lot more rules and regulations and requirements. When you're on the plaintiff's end, you're definitely much more of an entrepreneur for yourself and have the ability to take better control of the cases. And also, the people you represent on the plaintiff's side are people. They're not insurance companies, they're not corporations. So the satisfaction that I obtain when we get a really good or great result for an individual, a person, a family, is much more rewarding in my view than making sure that an insurance company increases their profits for that fiscal year.
Okay, so what do you see as the biggest challenge in that area of work?
And the plaintiff's end, is that what you're
And
asking?
in the work that you're doing, yes.
Well, I mean, the hardest part is that Chicago is a very competitive legal environment, and there's a lot of great lawyers on both sides of the bar. There are a lot of great plaintiffs' lawyers here in Chicago who I view as friendly competitors. A lot of them are very good friends of mine. But the defense bar has a lot of excellent lawyers as well. So on the large cases, the medical malpractice cases, the catastrophic injury cases, your opponent is almost always an excellent, excellent trial lawyer, and it's going to be a fight. And I don't mean that in a hateful sort of way, but they're going to do the best job they can for their clients. So the notion that someone just files a lawsuit and 6 weeks, 6 months, 2 years later, a big bag of money falls out of the sky is not the case. Uh, we have to prove our case, to establish our damages. At the same time, the defense lawyer is doing his or her job. They're doing the best they can to disprove liability and minimize or reduce damages to the best of their ability. So I enjoy that competitive part of the process, but it's an adversarial process. People have a job to do on the defense side, and they're not there just to roll over and pay you the money. They're going to make you work and prove your case.
Right. I see, the number of cases they are that you have published, at least on your website, seem to be quite complex. And as you're talking about working with opposing counsel on all you have to do to try to prove your case, how do you approach those complex cases from a mindset perspective? How do you, as an attorney, get into the mindset to tackle that complex case and win it for your client?
Well, a lot of research, um, you know, a lot of internet research, a lot of reading textbooks, talking to experts, because you have to become a subject matter expert in that particular field for each case you're going to handle. And you can't just wing it. You can't fake it. The experts on the other side and the defense lawyers on the other side are going to know the material really, really well also. So if you don't spend the time doing the research, talking to your experts, making sure you understand the science or the medicine as well as you possibly can, you're not going to do what you need to do for your client. And if the other side is doing it, then you're going to end up with a very bad result.
So, do you spend quite a bit of time then with your experts in that case development strategy, theory, talking it through, or do you bring them in and just base your further actions on their reports back to you? How do you engage them in that
We try
case?
to get with experts as early as we can in the process. There's nothing worse than taking a bunch of depositions in a case, reaching out to an expert, and you send them all the depositions you've already taken, and they say to you, or the discovery you've already requested, and they say to you, well, you didn't ask these 3 or 4 questions or 5 questions. And had you asked these questions, we would have found out so much more. So before we start taking depositions, it's really important to find out from your experts what information are they going to need to do their job well for you. And to do it backwards oftentimes leads to the result I just talked about. That, well, we didn't ask that question. We didn't get that document, and discovery is now closed. So what are we going to do? So the earliest possible moment, we try to engage with experts in the subject matter that the case is going to involve.
That's wonderful. I do a lot of work as an expert as well, and that's probably my favorite piece as a legal nurse expert is working in that close relationship with attorneys. So I think that's fabulous. And the more, would you agree that the more you can do that, the better your case is going to be? the value in those conversations from both your perspective, learning about the medical piece, but also from that expert's perspective and understanding the hurdles that you have to get over and how they can either help or not help that case.
Right. Some of the best help experts can provide, and especially when we use some nurse consultants on cases early on in medical malpractice cases, is when they tell us, here's the weakness in your case. Yes, you have a strong case. Yes, you have a viable case. But here's where I think you need to do some further investigation or keep your eye out on this issue. And again, knowing that before you start discovery is a great asset to find out for the very first time, halfway through the case that there's a weakness in your case. That's not doing your job. You need to know before you take the first deposition, where's the trap door? Where can I get into trouble? And if you use your experts the right way, you'll know that early on.
Mm-hmm. Would you invite experts to automatically provide that rather than waiting for those questions? Is that a skill set that they should come to the table with?
Oh, absolutely. When I talk to my experts, whether it's a nurse consultant or a physician or an engineer, they'll tell me you've got a great case. They deviate from the standard of care A, B, C, and D. They caused this injury. I'll almost always end every conversation by saying, so what haven't I asked you yet? And if you were on the defense side, what would you tell me is the defense in this case? If you had to try to defend this case, what are you going to tell me?
That's a
And I
great
want to hear
question.
that answer. If they're telling me, oh, there's no defense to the case, there's rarely a case where there's no defense. It may not be the strongest defense. It may not even be the one that's going to win the case for the defense. But if you don't know where they're going to go with their defense, you can't do a good job for your client.
Have you ever had anyone tell you that your case is not viable?
Oh, all the
And
time, all the
okay,
time. I mean, I'd say of every 10 calls on a medical malpractice case, we probably only end up pursuing maybe one or two of those after doing our initial investigation. A lot of bad results, a lot of tragic results don't result from malpractice. They're just, sometimes these things happen, unfortunately. So in Illinois, before you can file a malpractice case, you need to attach to your complaint a report from a physician who has knowledge of the area of medicine, who has to certify the case has merit. So without that report, you can't go forward. And it's a pretty common event that we'll send records out, sometimes just to a nurse for a first review or to a physician for a merit review. We'll be told this is not a case, or there might be something there, but there's a pretty strong defense on this case, and it just may not be worth pursuing. So yeah, that's a pretty common part of our practices. Getting the records in, reviewing them, talking to a consultant, and then making a decision that the case is not worth pursuing. And then we have to sit down with the client. We have to explain, here's what our experts told us. Here's why we are not going to pursue the case. And hopefully they understand our decision. They're certainly always free to go talk to another attorney if they wish. But you can't, malpractice cases are just too expensive to take a flyer on. You can't get halfway through a case, spend $50,000, $100,000 and realize on the eve of your experts or the eve of trial that this case has no merit and you have no way to win it.
Mhm.
So making those evaluations early on is the best way to handle those cases.
They are. So when working with you, specifically now for the legal nurse consultant, coming from my background, the audience gets curious about the most important things they can understand about attorneys when working with them. So when working with legal nurse consultants, what would be the most important thing you would like them to understand about you?
Um, that I, well, I think being thorough, but being concise at the same time. If the case involves um, a certain surgical procedure, I want to know what happened in that procedure. Let me know what took place. Ultimately, I may want to have a broader view of the whole medical background on the case, but I want to know, is this a case I should pursue? Is the injury one that's related to the alleged deviation from the standard of care? Once we get through that initial conversation, then we can talk about some of the sideline issues that exist. But I think that we have, we're all busy. Both the nurses are busy, the lawyers are busy, everyone's busy. So, I mean, being concise and being thorough is the most valuable uh, resource I find from nurse consultants who I speak with.
I would agree with that too, coming from the same perspective, serving attorneys. So, let's flip the switch just a little bit in talking about individuals and professionals. What advice would you give to the young you who is out there trying to figure out where they're going, what they're doing, what area of law to practice in? You have made your way into a wonderful profession and opportunity for yourself. There are other young attorneys out there looking to do the same. How do they get there? What advice would you give them?
I think it's really important to try to find a good mentor, someone who you can learn from. Ultimately, you've got to do it yourself and you have to stumble and fall down and get back up. But having a really good mentor who you can bounce questions off of and ask them, how do you do this or what do you do in the situation is a really valuable uh, thing to find early on in your practice. Even with a good mentor, still, you got to get out, do it yourself. You got to try a case. You'll win some, you'll lose some. Take some expert witness depositions. Sometimes you may get the better of them. Oftentimes you're going to go back to your office saying, I got nothing out of that. But you read the transcript, you see where you've missed a follow up question. You see where you could have done a better job preparing. You see where they dodged you on an issue. You can't be complacent. Always keep trying to get better. I routinely will poke my head into a courtroom over here at the courthouse if I've got time in between uh, status calls, and I'll watch people try cases. Sometimes you learn something new. Sometimes you learn something from watching something do a bad job. You're like, wow, I would never do it that way. And you see that. So, a good mentor, keep learning, always keep trying to get better.
I think mentorship has come up in just about every conversation that I have had. It's also very valuable in nursing, which I strongly believe that attorneys and nurses, probably physicians as well, have a lot in common in a lot of ways. Advocacy, justice, desiring to make sure that we do the best for the people we serve. Mentorship is one of the key things that comes up in every conversation. From your perspective, what makes a good mentor? What should people be looking for as they are growing in the practice of law for that mentorship?
I think one of the most important skills you can have as a mentor is one's patience, and two, an understanding that when people are asking you questions, they're not doing it to bother you. They're doing it because they genuinely don't know the answer or need some help. So we're not always in the right mindset to answer a question. We're not always don't have the time on our hands to maybe give to someone. But if they're going to ask you the question, make sure you can put down what you're looking at, put your phone down, turn your computer screen off for a second and answer their question. Because there's nothing worse than you ask someone a question and they answer you while they're talking, looking the other way. Give them the time that they need. Um, and if you don't know the answer, sometimes you can learn yourself. You say, you know what? I don't know that answer. And that happens more and more often these days with technology. Um, AI is becoming a bigger part of all of our practices. And sometimes you're asked a question, I just don't know what the answer to that is. Or I'm not sure what the rule is on that anymore. You got to find out. So mentoring is not just, you telling someone what's going on. It's a way for you to learn as well.
I agree. I find that in our profession too, that oftentimes I'm learning as much, if not more, along with the person that I am helping along, which is great because it helps keep us active and fresh in our practice too. Challenges us from a lot of different ways. You mentioned AI. How is AI impacting your practice and your casework?
Um, AI is becoming more and more a part of our practice each and every week. Um, Whether it's simply helping us create medical chronologies in some cases. I just had to answer some expert witness disclosures in a medical malpractice case. And after I created them, I put them into our AI program, and I asked the AI to identify for me the weaknesses it could find in our experts' opinions. And I looked at those to see what I thought of what they had to say or what the program had to say. And again, it's a way of knowing what the weaknesses may be in your case. So medical chronologies, summaries, identifying weaknesses. We have used it to do a lot of first drafts of demand letters in cases. I always refer to AI as a really good summer law clerk. You can't just rely on it, but you can. It's a great first draft. It's a great tool to use to help you be a better lawyer for your clients.
And I think you hit the nail on the head with the word tool. Are you finding that there are times where it's not so accurate, that things could potentially slip through that wouldn't be truthful or are not really there?
I have not had a situation where it's hallucinated a citation to a case or things like that. But, excuse me, I've seen where the approach it takes to a situation or what we're looking at isn't necessarily the way we would do it. Again, it's a really good summer clerk. It's a really good first year associate that may take a very simple question and complicate it beyond what it needs to be, or may miss the assignment entirely. But you have to learn how to use it. Sometimes there's the follow-up prompt. So you get the first draft back or the first response back from AI, and then you have to, narrow it down. Well, what about this? And I used it in a case recently where I was trying to find out if what my expert was telling me was accurate. I sort of pressure tested what the expert said to me through the AI, and it was very helpful. It was very helpful. But I've not had a situation myself where I've had them hallucinate a website or a case citation or things like that. But you do see about it all the time in the legal newspapers.
You do. And I still see ads out there that, oh no, AI is going to replace all of us in this business. Do you think there's truth to that? Or do you think that's
Not
a
going to
fear
replace
tactic?
all of us. I do think that there are skills that or tasks that AI is going to replace. I mean, I think it's just the way the world's worked for a long time. I always use this example that when I went to law school, between 1988 and 1991, it's a long time ago now, that we learned to do legal research on books, the Westlaw Digest. And there was one class that we had, legal writing and research, about this new thing called LexisNexis and Westlaw. And the professor said to us, but you can't rely on it because it's too expensive and clients aren't going to pay for it. Well, that was 1988. And here we are now in 2026, and there's very few people doing research on books anymore. It's all on the computer.
Yeah.
My first job, there was a full floor of a library all full of books with librarians and people in, to help out with that. I think very few firms now have full libraries with books. So, yeah, the practice is going to change. There's no doubt about that. But AI is not going to replace lawyers entirely, but it will, I think, affect or impact people that are nurse practitioners. We've relied on nurse consultants to do chronologies and summaries for a long time. And on a big complex med mal case, I would probably only use an actual nurse consultant, a human being. But on a routine automobile accident case, that's a case where, uploading the records into the AI program and getting back the chronology could be the more cost-effective way. So I think it's just going to be how well you use it and how you can balance it with your practice. But you can't talk to the AI. I know you can do follow-up chats with them. I like talking to people. It might just be, generational sort of a thing, but I like being able to get on the phone with my expert, talk through stuff, look at records, and do stuff like that.
Well, there's a benefit to being able to hear what is being said as well, and it generates that creativity in the brain. Anything anyone says could actually trigger another thought that might take your case in a whole different direction. So I agree with that as well. I find AI to be a very useful tool, but it's about workforce adaptability rather than replacement. And so I like that perspective. I like hearing that perspective. So for the listeners, what sets you apart from your competitors, and why should they choose you? if they are in need of a personal injury or wrongful death or car truck accident attorney?
I think what makes my firm, Mitchell Hoffman and Wolf, pretty unique here in Chicago is that the three partners, myself, Paul Wolf, and Jay Mitchell, we're still hands-on every case. If you come to our office with a case and you've had a serious injury occur and you need help, and you meet with one of us, we're going to be your lawyer on the case. We're not going to hand you off to an inexperienced first-year associate. We're not going to, disappear. If you have a question about a case and we're handling the case for you, you'll have our cell phone number, you'll have our email, and I make sure everyone knows it. I work for you, you don't work for me. So if you have a question, call, text, let me know, because I'm a lot of things, but I'm not a mind reader. So I don't know if you have a question, but you shouldn't go to bed at night worried about something that I can answer, put your mind to rest. So I think our hands-on approach and is really makes us unique here in Chicago. Again, there's a lot of great law firms here in town, and I'm not saying anything bad about anybody. I never would do that. But I think what makes us really unique is what I just said. If you meet with me day one, I'll be there at your deposition. I'll be there at trial. I'll be there taking the expert depositions. We have paralegals. We work together on files. My partners and I will brainstorm all the time. But I'm not going to hand you off to somebody who doesn't know anything about your case or is just 1 year out of law school.
About building the relationship and establishing that level of trust. I think that's important. So tell us one thing about yourself that would surprise others to learn or know about you.
I think that would probably be that every morning at 6 a.m. I go to a yoga class every day without fail. It's been that way for about maybe a dozen, 15 years now. I got started doing yoga sometime in the late 2000s, 2007, 2008. And I just found it to be a great way to start my day. And I'm lucky enough to have a yoga studio not far from my home that has a class every day at 6 a.m. And believe it or not, I'm not the only one there. They get between 15 and 30 people every day. And I go every morning, and that's how I start my day, no matter what. I miss once in a while if I got an early court call or I'm on trial. But if I can get there, I get there. It's how I begin my day. It's a great way just to sort of, clear my head, get ready for my day's work. And I really love it. So I think people don't always view me as being a yoga type person, but I do it every day for about 15 years.
That's wonderful. And I think that could be a whole nother podcast on how to ground yourself so that you are more focused and productive during your day. Because I'm sure I don't do yoga in the morning, but I have another method of grounding myself in the morning. And if I miss it, I feel off. Every day I feel off. And I find, I don't know if you share that same feeling, but the more focused you are, the more grounded you are, the more work productive you can be, and actually have a much higher quality of life as well, because there's just time to do the things that matter the most. Do you feel that way, or does that?
Oh, absolutely. I mean, I don't think I meditate in the truest sense of the word, but I do know that my day is better when I spend that hour, uh, you know, at yoga. And I start my day. I get up at 5:30, get changed, go to the class, get home around 7:15. I know at that point I've sort of got my day off to the right start that I want. And days that I do have to miss it for whatever reason, and they're very few, I don't feel as good, and my head's not as sharp. So I really, really enjoy that routine. And like I said, there's a pretty steady 6 a.m. Crew that comes to the studio every day, between I say 15 and 30 people every morning.
That's great.
And most people are on their way to work right afterwards. They're lawyers, they're school teachers, they're business professionals, and everyone kind of has the same feeling about it. It's just a good way to sort of jumpstart your day, get your mind clear, and make sure your battery's properly charged.
That's great. Ken, I would like to thank you for joining us today. This has been a pleasure having the opportunity to talk with you, get to know a little bit more about you, and share your expertise with the audience. I am hoping that in the future you'll come back again.
I'd love to. Thank you for
That's
having me.
great. That's great. That's wonderful. For our audience, Thank you for spending time with us today. If you enjoyed this episode, make sure to subscribe, share it with someone in the legal or medical world, and keep the conversation going. This is Jamie Gary, the founder of UpVision Consulting LLC and the Attorneys Resource Conference, reminding you the story is always in the medical records. We will see you on the next episode.
If you have found this episode valuable, be sure to like it, subscribe, leave a review, and share it with a colleague handling medically complex cases. If you are an attorney looking for deeper medical insight to strengthen your case strategy, or you are a legal nurse ready to elevate how you support litigation, I invite you to connect with me and learn more about UpVision Consulting LLC in the show notes, because stronger collaboration leads to stronger outcomes.